So the Bowers case is a relatively easy application of the government publication exception or the self-authentication um, rule to government publications. Here you've got a dictionary of American naval fighting ships that's more than 20 years old. So the bulk of the case is not about authentication. The bulk of the case is whether this document comes in as an ancient document because it's more than 20 years old, or comes in as a learned treatise, in which case you cannot use self-authentication as a way of bringing it in. You have to have an expert on the stand who talks about it. So, or makes reference to it in some ways. Yes, this is, this is the prevailing text in the area. Now, it can also be judicially recognized as a learned treatise, but that would have to happen. And didn't happen in this case. It was simply offered as a self-authenticated document because it's a government publication. So what I really like about this case is that it shows the interplay between the 803 exceptions and the self-authentication provisions, because as I said, much of what we're looking at with 902 is really just sort of like cleaning up, putting a final bow on the package that we've been wrapping for hearsay. So if this document comes in as a learned treatise, we would either have to have someone on the stand talk about it, or in the case of a really, really well-known treatise that every judge in America regards as a definitive treatise, Gray's Anatomy being probably the best example of that, then that would have to happen if it's a treatise. If it's an ancient document, then the mere fact that it's published, the mere fact that particularly that in this case, since it's published by a government publishing government agency publishing this document, the fact that it is a government publication allows under what was 905E and is now categorized as 902E, and it's now categorized as 902.5 under the self-authentication exceptions to the authentication requirements. This document, the portions of this book come in because you look at them, you look at the cover, the book looks intact. The publishing, the notes that indicate who published it suggest that it was published by a government agency. In fact, they reveal it was published by a government agency. That satisfies the requirement under 902.5, which used to be 902. 5 now. It used to be 902E, and it's therefore admissible because the court says we do recognize this to be an ancient document, and they do so because that there is no limitation on ancient documents. It's not limited to deeds or wills or those kinds of things. So once something is more than 20 years old, you get this kind of odd notion. So if you get a copy of Gray's Anatomy that's from 1975, you can bring that in as an ancient document. Whereas Gray's Anatomy from 2015, that one you're going to have authenticated through the process of either having the witness acknowledge it or having the judge take judicial notice of the fact this is a scholarly treatise in this area. The reality is, for something like Gray's Anatomy, or even for something more obscure, the reality is that you're going to want the expert there anyway. And for something like this, we don't know the full context of the case, but you can imagine that the expert was kind of superfluous. So whether you actually have to have an expert or not, it will depend on whether it's an ancient document, whether your treatise is an ancient document or something more recent. That's your practical legal bar exam answer. Your practical trial tactic reality on the ground is, regardless of whether this is something that is more than 20 years old or not, you're really going to want an expert there to talk about it. I wouldn't say, well, here's what you can do. If you need to show where the spleen is, why don't you bring in a copy of Gray's Anatomy that's more than 30 years old, and therefore bring it in as an ancient document? You could do that. The rules would allow that, but it's not the smart thing to do. You're going to want to have someone to explain a complicated text to the jury. It wouldn't have hurt anything in this case. And my guess is the fact that there was no expert was more a function of the fact that, much like we saw with the Blue Book in the Louisiana case establishing the value of the car, the fact that no expert was brought in is because it's really simple. You look up the year, you look up the model, you look up the mileage, and you get a number. There's nothing complicated about it, regardless of what the rule says. If you're explaining something with any complexity to it, you're going to want an expert on the stand to walk the jury through it. In this case, though, your Hornbook answer is that if it's more than 20 years old, and you can show the publisher, and the publisher is a government entity, then under, I'll get it right this time, 9025, then it absolutely comes in, it's self-authenticating. We just look to the title page and ask who the publisher is. If it's a government entity, that's 9025, and that's admissible.